My name's Dan Jackman, and I'm the reporter appointed by Scottish ministers to consider the two appeals by Rivertree Residential against the failure of Perth and Kinross Council to give a decision for A, residential development, and B, change of use, alterations and selective demolition to form 58 flats at the former Murray Royal Hospital, Perth. If I can quickly run through the usual housekeeping points. The hotels assured me there will be no fire alarm practice this week. So if we do hear the alarm, it will be for real. If we do, I suggest we stay calm, and we will need to go through those doors and gather on the Riverside car park, where no doubt a member of staff will assist us. The toilets are back out into the foyer reception area. Can I ask that all mobile phones are turned off or turned to silent, please? Can I check that everybody can hear me? Is that okay? Good. We've also, all these proceedings will be webcast live, and you'll also be able to see them on our archive webcasts. So if you wish, you can watch yourself on TV tonight. Also, with me is our technician, Mr. Ewan Murray. If you have any questions about the sound systems or the webcast equipment, Mr. Murray is your man. Can I go round the tables now and ask the parties to introduce themselves, starting with the appellants team?
Yes, sir. My name is James Finley, Queen's Counsel. I'm instructed by Craig Welton from Burgess Salmon, who sits at the end of the table. Sitting to my left is Fraser Littlejohn, and to his left is David Berger, whose details you should have. I should say Fraser Littlejohn is from Montague Evans and is going to be the primary speaker at this morning's session.
For the Community Council.
Good morning, sir. My name is Graham Fleming, and on my right from the Community Council there is Dave Beattie, and on my left, Jack Rivet.
Thank you. And
I'm Colin Elliott, solicitor from Perth and Ross Council. To my left is Steve Callan, Planning Officer. To my right is Alex Deans, who is Transport Planning Team Leader.
Okay, thank you. I want to explain how I'm going to run this examination this week. The 3 hearing sessions will be a structured discussion that I will lead based on the agendas I have circulated. I will not allow any formal presentation of cases or cross-examination. I shall lead the discussion by starting off each item on the agenda by directing a question at one of the parties. After the answer, I shall invite the other parties to comment in turn. This usually kicks off a discussion and frequently generates other questions I need to ask. If you have any comments and questions as the discussion progresses, that's fine, but please make sure they come through me as chair and let the other party finish the point they are making, even if you strongly disagree with what's being said. In fact, particularly if you disagree with what's being said. The inquiry session tomorrow is a different format, and I will explain how that will work when I open that tomorrow morning. I shall be adopting a brisk pace. I will move on when I consider I have all the information necessary to make my decision. Don't feel obliged to comment if all you're doing is repeating what you've already told me, or if it's better explained in your written submissions. I recognise that there is a considerable interrelationship between the three matters that we will be discussing in hearing sessions, and I will adopt a pragmatic approach as to what I hear when. The key point is that I get the information necessary to make my decision. There are occasions where I may direct a series of questions either at the appellant's team or the council's team. I hope the Community Council won't feel left out. I can assure you that before I move on to another item on the agenda, I always check that if you have any comments to make. The policy session looks a long and detailed agenda, but in my experience, once the discussion gets going, many of the points I want answered usually get answered. The bullet points are therefore more of an aide-de-memoire for me rather than an exhaustive list of points that we must plough through. We previously agreed to nominally allow a day for each hearing session and 2 days for the inquiry session. That built in a little bit of safety. We will discuss progress as we go along because it's very hard to predict timetabling matters. There will always be a mid-morning, lunch and mid-afternoon break at appropriate points. We have booked this room all this week, so you will be able to leave material overnight, but it will be at your own risk, obviously, and the doors won't be locked. So it's up to you how precious your hearing statements are. In my experience, it's very likely as we go through the hearing sessions and the inquiry sessions, there will be matters that arise that may well need further clarification, or perhaps even I have to give homework to the parties. So after the last hearing session and before I let you all go home, we'll have a little wash-up session to make sure that we've cleared off any points and that we've agreed the timetable for submission of closing submissions. All that you tell me is evidence that I may have to include in my decision, and you will see me take notes. I may have to ask you to pause from time to time so that I can catch up. I've also downloaded all the documents on my tablet, and again, every now and again I may have to ask you to pause whilst things load, particularly if it's a very big document. We'll be spending the week together. It's okay to talk to the reporter, but please, I can't discuss the merits of the case. Now, I have a number of procedural points I want to discuss following on the exchange of emails last week. Can I just go round the tables? Mr. Finley, do you have any procedural matters you wanted to raise with me?
Yes, at an appropriate moment, I did want to raise the position, the status of the Council's evidence, which has to an extent been explained to me this morning, but it should be made public, and just to confirm what documents you've had, because there were some additional documents came in last week.
Committee Council, any procedural points you'd like to raise?
I don't think we have any procedural points.
For the Council?
I think the only procedural element would be the update we gave to yourselves by email on the timescale for CTLR and the LVP2. It's kind of procedural, kind of merits. That's what we intimated a few days ago.
Okay, thank you. So I think we'll start with you, Mr. Finley, then. If you wanted to say something about the status of the Council evidence, if you could start with that then.
Yes, sir. You will recall it's a point that we raised at the pre-inquiry meeting is picked up in Mr. Littlejohn's statement and was raised by email on Friday. I understand from there are two matters. One is a distinct legal matter. Are the council actually authorised to appear here? And I always thought it would be very surprising if they weren't, and I'll come on to that in a moment. But the second is to know the basis on which their evidence is given, so that you can determine what weight to attach to it. And just so that I provide a background, quite commonly where there's a non-determination appeal, the council who is resisting the appeal will take the matter back to the decision maker, whether it be the officer or the committee or the full council, to have their position authorised as representing the council. Now, we know that that hasn't happened in this case. Also, on a non-determination appeal, it can be the case that the council decides that its position would be that, had it determined, it would have refused. We, as evidence does as I and that's obviously a matter that's the weight we're looking for. But so that's the outline. Coming back to the first point, which is authority, I've been shown this morning the council's delegated authority, which, not surprisingly, gives the chief legal officer and those sub-delegated by him the authority to appear at proceedings, including inquiries, to represent the council, so that they are not here on an unauthorised frolic of their own. They can draw their paycheck at the end of the day because they're doing what they're authorised to do. However, so that's a sort of strict legal analysis. Authorised. This on which they've reached their decision and which officers have been involved in determining what the position that has currently been reached. It clearly hasn't been reached at by a council whom to not follow the first time round and deliberate further. And it's unclear to us that the basis on which the decision has been taken to maintain their current stance, which is, as I understand it, to raise concerns, and the basis for those concerns. Now, to an extent, I obviously accept that the basis for those, the broader basis for those concerns, their evidential basis, is set out in their hearing statements and inquiry report and precognition. But it's the decision-making process which led that to be the council's case, which is, I understand, what they suggest it is. And in our submission, it's important for you to understand what is meant by the council's case and what process has led to that being put forward, because it's not the usual process that one would expect. I don't mean there's anything untoward necessarily about it, but it's not the usual process one would expect. So it's clarification of those issues that is the first point that I'd seek to raise.
Okay, I'll ask the councils for comments in a minute. Is there anything you think I need to do about this?
No, but to obviously, because I've accepted that the council have authority to be here, then you should hear their evidence. But yes, to listen to their answers and to judge the weight of their evidence accordingly, which I'm sure you would do in any event. So that's, to a certain extent, teaching my grandmother to suck eggs. But the only thing I'm asking you to do is to ask the council to answer the points that I've raised, and then I may or may not make further submissions thereon.
Councillors, any thoughts or comments on what you've just heard from Mr Finlay?
Well, first of all, thank you to Mr Finlay because he has accepted that we have authority to appear. We obviously cannot appear in our personal capacity. We appear for the council on this occasion. I think he's left with the one point as to what the status of what we're saying, and I'm reverting back to what was said at the pre-inquiry meeting by myself, is that we are raising grounds of concern. You will recollect that it went to committee in October 18. The committee deferred for further information, and it has not gone back to committee. It wasn't through discussions it was felt not appropriate in the circumstances to put it back to committee. This is now a non-determination appeal, of course, and the decision rests entirely in yourself. Now, I think where my friend's been driving at from our discussions is there any formal recorded decision of the council objecting to the application? Well, the answer to that is no, because it's not been put back to committee. Now, the status, what we have now, is that the authority to present concerns vests through the council scheme of administration. Bear in mind that's the council scheme of administration, so it's for the council. It invests in my head of service, head of legal and governance services, who has then vested that in myself. So, coming back to what we said at the I said at the pre-inquiry meeting, these are grounds of concern for you to take into account, and then obviously make your mind up on both of the appeals. Those concerns can be quite serious, particularly on the traffic impact side. But ultimately, these appeals are a matter for yourself to take a decision.
Does the Community Council have any thoughts on this?
We don't have any particular input on this one, so.
Did that clarify your points, Mr Finlay?
To a certain extent, and to a large extent, I should say, there's no objection. The matter has not gone back to committee, so one can recall that the committee has not endorsed any of the concerns. But what is still unclear is the extent to which, or the nature of the decision-making process as to who decided and on what basis which concerns to raise, and which concerns, and the basis for the assertion that some concerns are more serious than others. Those remain undisclosed, and that lack of certainty in our submission, I will submit in due course, goes to the weight to which you can attach to them. And the council, I'm not asking for a response from the council at the moment, but if they wish to respond to it, during the course of the proceedings they can do, but I've set out what our position is likely to be.
Right. For the purposes of today's hearing, is this something that if it needs to, the parties could include in their closing submissions?
Yes, and that's what I was presaging in my remarks.
Right. That's one procedural matter ticked off. Can I just run through some of the things that I think I received last week? On the 18th of July, the appellants team submitted a supplementary report from Mr. Diamond, including attached spreadsheets, which had previously been given to us. Unfortunately, I never actually got those personally until Friday afternoon. So I've obviously had a chance to read the two sides of paper, but what I would ask Mr. Finlay is if in your evidence in chief tomorrow you can make sure that Mr. Diamond has a chance to explain that supplementary report. The Community Council also lodged two additional documents in response to that. I have no objection to additional documents in principle. They are quite long, and again, I only picked those up on Friday afternoon, and I haven't been able to read them properly. What I suggest is that we hear the evidence tomorrow, and once that's been done, before I close the session, you can let me know whether you wish to formally lodge those two documents, and what mechanism we will use for you to draw out whatever conclusions you feel I should take from that, and other procedures that the parties might want to comment on that. Does that seem a reasonable way forward?
So quite happy with that, but could I add one request to the Community Council, which I think Mr. Welton made by email, was that if there were any particular sections of the lengthier document upon which they were seeking to rely, it would be only fair to alert Mr. Diamond to that today, if possible, so that he can consider them overnight, because it is quite a lengthy document, as you say. And I don't think they're referenced in any of their previous communication.
Yeah, perhaps I could ask the Community Council's team to talk to Mr. Wilson at an appropriate break. If you were going to ask any questions of Mr. Diamond in relation to those two documents, then it would only be fair to give fair warning. But again, I think we could deal with this if they were essential for my determination by further procedure, if necessary. I also received an email from the Perth and Kinross Council about the timetable for the Crosstay Link Road and the Local Development Plan 2, and no doubt during this week you can expand on that. So I'm sure that will come out in the wash. I don't think we need to discuss that anymore. The appellants team also submitted conservation plan amendments. Again, I think that's all going to be thrashed out in the wash when we come to the design hearing session. And again, if these need to be formally submitted documents, we can perhaps discuss that at the end of that hearing session. Does that seem a plan? Yeah. What do we got? Oh, yes. We also had a statement of agreed matters. I have to say that I did ask the parties to undertake that exercise. Obviously, I prepared for today's hearing based on the hearing statements that were submitted a month ago, and I'm going to stick to that preparation. So I have had a glance at the statement of agreed matters. I think in practice, again, everything's going to get thrashed about today. I don't think we'll need to refer to that. But if we do, then we can again discuss whether that needs a separate procedure after today. That was all my procedural points from the emails that came in last week. Is there anything else? Mr. Finn.
There should have been, we were wondering whether you received some draft conditions towards the end of last week.
I couldn't read my own writing. I did see a set of drafts, and again, I think we'll give this a good thrashing at the conditions session. So whatever. What the point I'd make to the parties is I've prepared for that hearing session based on what was included in the hearing statements, so I haven't taken into account, and I'm not going to take into account, something that came in on fairly late last week. It may well be, after our discussion at the obligations and conditions session, that we need to have a further exchange to set out people's positions. Anything else? Community Council, all done? Right, can we move on to item 2 on the agenda, the legal framework? I hope the parties will believe me when I say I'm familiar with Section 25 of the Town and Country Planning Act, but is there any other legal framework provided by the Planning Act that we need to discuss? The Council.
Section 37 of the Planning Act and also Section 59 of the Listed Building Act.
Okay, we'll come on to the Listed Building Act in a moment. For the appellants, any particular legal framework from the Planning Act apart from Section 25 that we need to discuss?
Nothing further, sir, from our perspective.
Community Council?
No, nothing.
Okay, if we now go to the Listed Building Act, if I can start with the appellant. In your hearing statement, you refer to Section 64. My understanding was the site was just outside a conservation area. Does Section 64 apply?
Sir, that's exactly right. The site does not fall within the conservation area. The reference was simply added to further make the point in terms of the weight.
And if I picked your hearing statement up, the principal point you're making is that, in your opinion, the proposals as a whole would preserve the listed building and its setting, and that's a very important consideration for me. When I'm having special regard, as I'm required, should I look at each application individually or combined? Or is it a bit of both?
Sir, from our perspective, I think it is extremely important to consider the site as a whole. Ultimately, when we progressed discussions initially with Perth and Kinross Council, we spoke about combining the two proposals in a single form. Ultimately, that was something that the council did not feel that they could progress. And latterly the application was divided into the principal application in terms of the main building and the application for planning permission in principle in relation to the development across the wider site. I think we've made it clear within our hearing statement that the new build development is required to facilitate the refurbishment of the main listed buildings, which will be retained on site, which is clearly very challenging in the current circumstance.
Okay, councils, any thoughts or comments on that?
We were looking at it from a cumulative perspective in terms of planning application in terms of Section 25, but also Section 59 in terms of the impact on the setting of a listed building and also the impact actually on the listed building itself.
So you would agree that I should look at both applications together rather than individually?
I think you could look at both applications together.
If I can just turn to the appellant, perhaps you can clarify the position with regards to the chapel. It's within the red line for the application for detailed permission. It's a listed building, but as I understand it, you're not making any changes. How does that sit?
Certainly, sir, that's the case. The chapel falls within the red line application boundary. We clarified within exchanges, I think, with both Historic Environment Scotland and Perth and Kinross Council, that there were no detailed proposals relating to the chapel at this stage. The broader aspiration is that the chapel may form some form of community asset within the site, but short of refurbishment works which would not require consent, there's no intention at this stage for change of use, for example.
Okay. The council, is it your position, leaving aside traffic impact, which we'll talk about tomorrow and Wednesday, do you consider that both proposals preserve the listed buildings?
If I could kind of maybe step in to kind of categorise it, please, that there's a kind of a step process here. In terms, on the face of it, in very outline terms, the proposal is to change the use to residential, and in that sense that preserves the listed building. However, the Section 59 test also has kind of, you might describe it, a more negative assessment, which is preserve the setting. And of course the council has expressed some concern in the design considerations part of it about the preservation of the setting of really the main building, not the Elcone burning towards the main building. So you have a step-by-step process. So you've got preservation of the building because it's getting converted, but then there's the assessment of the setting, and that's in terms of the planning listed building act. But of course you've still got section 25 of the other 97 act to consider.
I just thought, in answer to my previous question, that I need to look at whether the test in the Listed Building Act, I should look at the whole, and you've just split them up.
I'm not sure I have, in the sense of you're putting the potential new build against the listed building and the setting of it, so you have to see what the impact is. So that's, in the sense, you're looking at the whole.
Am I getting you right? I have to look at it as a whole, but in a stepped process. Is that fair?
I think the emphasis, because Section 59 is very much the emphasis is on the preservation of the listed building. So you're primarily looking at that, but there's two factors you're looking at, if I could put it that way. You're looking at the preservation in a general sense because it would become residential, but you're also assessing at the same time, if you like, you're looking at the setting and the impact of potentially these new builds on the setting of the listed building, and you're taking all that into account together.
Okay, and so taking all that into account together, does the council have a position as to whether overall, or perhaps separately, the two applications before me comply with the tests in Section 59?
Yeah, principally we still have concerns over the impact on the setting of the listed building.
Thank you. Appellants, any thoughts or comments on that?
Sir, I was just going to add that from my perspective, and I think the point that has been made by the Council is that it's about a weighting, I suspect, of the decision. As I mentioned within paragraph 220 of my hearing statement, the appeals are very much brought forward with the stated intention of preserving these listed buildings, including the Category A main listed building. This is both accepted, I think, by the Council and Historic Environment Scotland, who do not oppose the proposal. Pursuant to Section 59 of the Act, the preservation of the listed building must be given that special consideration, and I think it's that weighted point in the context of Section 25 and Section 59.
And unlike the council, you have no doubts that both applications before me would comply with the Section 59 test.
Yes, sir, that's our position. Yes, sir, just by way of a further clarification, as you know, there's a separate application for listed building consent, which is currently being considered by Perth and Kinross Council. Just, I think, at the beginning of last week, we circulated an update to the conservation plan, which you'd alluded to having seen, and some further drawing information, which I understand is being considered by the council at this stage, and further feedback awaited. We are hoping that matters can now be progressed to determination.
Okay, thank you. Community Council, any thoughts or comments on what you've just heard?
Yes, one point for the sake of clarification is that when we're talking about listed buildings here, we need also to remember that that includes the wall along Muirhill Road, and that becomes particularly relevant with regard to the point being made about the setting.
Okay, thank you. And I'm sure we'll get into the detail of all this at the design hearing session. Is there anything more we need to discuss about the Listed Building Act? Are we done? Okay, can we now turn to the next bullet point? And I did flag this up at the pre-examination meeting. It's very likely that these two proposals will be the first in Scotland to where Regulation 29 of the 2017 EIA regulations will apply. Now, obviously, we at the DPA have been looking at the law and the circulars, but I thought I would raise this with parties. You have an interest in me getting it right. So that's the background to that. If I can start with the appellant on the first bullet point, summary of information. One of the requirements now is that there needs to be a summary of environmental information and the results of the consultations. Would it be adequate for me to merely cross-refer to, say, the report of handling or the environmental impact assessment, or must I, in my decision, actually summarise the whole EIA? Any thoughts?
So I think from our perspective, you're quite entitled to cross-refer and effectively incorporate by reference. Obviously, that answer wouldn't necessarily comply in every case, but if you were satisfied with the findings, then you could, to my mind, simply cross-refer. There's no need in that putting form over substance to require you to repeat everything within it.
Okay, thank you. Council, have you been doing any thinking on this matter?
Mr. Callan's done one already, so he can explain.
Yeah, we have recently issued permissions where there's been an EIA involved, or an EIA addendum in particular, and we have provided at the end of the decision, after conditions and informatives, a summary of the EIA in terms of the proposal, the impact, proposed mitigation, and what conditions will be that are listed above that will be relevant to mitigating that impact. It's a short statement, 2 pages, but it is something we have been doing recently since the 2017 Act came in.
So that would be a kind of an annex to the decision notice, you know?
Yeah, it's an annex, and it's in addition to what goes into the advert in the Edinburgh Gazette as well.
For the Community Council, this is an example where I'm going to pick these guys' brains for a wee bit. The other thing is if, in the event that I decided to grant planning permission, I must give reasoned conclusions on the significant effects. Does that mean I must set out my reasoning for disagreeing with the EIA in my decision? And I'm conscious that there could be a difference between significance in EIA terms and the planning balance in terms of the merits of the case. Any thoughts on that?
Yeah, we're simply looking at a summary of the environmental effects. Some may be positive, some may be negative, some may be significant, but it is just a summary of the effects.
I was thinking of situations where, and we'll come on to this, the next few bullet points, that I might be persuaded that something, I might disagree with the EIA in terms of it not being significant, but not persuaded that it was unacceptable in planning terms. You can see there's a distinction. How would, any thoughts on how I would have to deal with that in my decision?
I think that there's an issue in terms of how we are talking, of course, about the summary and the decision notice. But I think the problem is, from our perspective, there are obviously significant concerns. Sorry for using that, I use it in a different sense, on traffic impact. So actually that comes before we get on to this, in the sense that if you take the appellant's position, there is no issue. So therefore there wouldn't be significant effects. But if you have concerns about the transport assessment, about not reflecting conditions and not reflecting the impact of the development, then I don't think you get on to the decision. You need further information, the sustainable travel information, before you can take a decision in terms of other parts of the EIA regs, particularly Reg 5.2.
I think we'll come back to this when we look in subject matter in the detail. Appellants, any thoughts or comments on what you've just heard?
So just looking at the regulations, the reasons you have to give are the reasons for the decision. So 29(2)(b) is the terms of the decision, C is the main reasons and considerations on which the decision is based. The summary of the environment, paragraph E, which deals with the summary of the environmental information, results, the consultations, etc., is summarising the information. So it is almost inherent if you are, because you'll be giving a fully reasoned decision, you are likely to reach a view on significance of effect, for instance on traffic matters, and then go on to determine whether that's acceptable or unacceptable. But the requirement is the main reasons and considerations on which the decision is based, rather than, certainly as I read it, as to whether you agree or not with the environmental information, although one is probably likely to be included within the other. And if I can say in response to Mr. Callan's point earlier, when the council's issuing a decision, it's almost bound to have to include an extra summary at the end, whereas because it's not issuing a reasoned decision, whereas if you were to grant planning permission, your whole decision would be the grant of planning permission and can be taken into account in interpreting what that means and what has been taken into account of, whereas the decision, a council decision, would stand at least ostensibly separate from any officer's report that lay behind it.
I was just thinking of Regulation 29 F2, the reasoned conclusions on the significant effects of the development. Do I take it your advice is that because you would be addressing the planning balance, for all practical purposes, you would be addressing whether you agreed with the significant effects or not?
I think you would. So you would effectively have to, because it's difficult to conceive of a decision where if you disagreed with them, that wouldn't, and it was an important element, that wouldn't be something that you would have to grapple with in your decision letter.
Thank you. If I can turn to the council, and the following bullet points are chapters of the environment chapter that I thought you might take issue with. I'm not sure. I just highlighted those chapter headings, and if I can run through those to see if you have a position. So the first one is built heritage, and the environment statement made a finding that there was not a significant impact. Would you take any issue with that finding?
We would still state that there is an issue in terms of the consultation feedback that we got from our conservation planner, that there was a potential impact on the setting based on the indicative plans shown in the in-principle application.
When you say still an issue, does that mean you don't accept that it's not a significant impact?
Yeah, we consider it negligible. Yeah, we don't.
Right, so I just want to be clear of your position, and if you don't have one, then you're allowed to say that as well. But the EES, which is before me, makes a finding that there is not a significant impact on built heritage. Do you agree with that conclusion?
No, we do not.
You're saying there is a significant impact?
We're saying there is an impact to the level that we have concerns.
Okay. I think I will just go back to the appellant as I run through these. Now, any thoughts or comments on that?
I'm confused because Mr. Callan said, in answer to your first question, we consider the impact negligible, having discussed it, and now he said we consider there is an impact which gives rise to concern. But an impact which gives rise to concern doesn't necessarily mean the council have formed a concluded view there is a significant impact. So, with respect, so we would request through you to have clarification of what the council's position is, because we hadn't understood there to be a particular concern about a significant impact on built heritage before.
Yes, can I just go back? What I took from your answer was that you had no view on whether it was significant or not.
I don't think that was intended, I was kind of correcting Mr. Callan. He inadvertently came out with it is negligible impact. In the consultation responses received, which you have before you, I think there's a conservation officer and historic environment in Scotland as well, to my memory, disagree with that statement about negligible impact. There is obviously, and that comes on to the issues, that was in relation to the issues of the issue of setting, the impact on the setting of the listed, main listed building. We think that is greater. And of course, when we come on to the design considerations, there are concerns being expressed there. Of course, you do not need to agree with that, but that's the context.
I understand that. I understand that you don't accept negligible. There's obviously a degree. There's degrees of significance expressed in the environment statement. You'll be familiar with the matrices that are used. So, whilst you don't agree it's negligible, would you go so far as to say that it's reached the moderate major impact, so that it is significant in EI terms, or do you not have a position at all?
Okay, we consider it it's bordering between moderate and major. And major.
Well, I'm not going to look up the tables to find out whether that's significant. I'm going to make a note. Let's run through these others before to see how many other outstanding items there are. Please bear with me. Let's just run through these and we'll have a look at the end. I'm hoping the other ones will be easier. The Town and Landscape Visual Impact chapter found not significant. Would you take any issue with that?
We have some moderate concerns on the impact on the boundary, particularly.
Perhaps I'm not making myself clear. I appreciate there are impacts, and we'll discuss this at the design hearing session. I'm now focusing solely on significance in terms of environmental impact terms. And the reason that's important for my decision is that if I was minded to grant planning permission, we've just discussed that the regulations, if I choose to disagree with one of the findings in the environmental statement, I need to explain why. So I'm trying to capture the council's position. I know the appellants because they wrote the environment statement. So I'm trying to capture the council's position.
The concerns that we have are mainly in relation to the in-principle application in terms of the impact on the wall, which is covered by the listing, and also in terms of the proposed breach shown in the indicative plans, but also the indicative plans also show housing backing on to the boundary wall, and that raises an element of concern to do with the in-principle application.
So I understand that, but my question to you is, the environment chapter entitled Town and Landscape Visual Impact made a finding that the proposals before me were not significant. My question to you is, do you disagree with that finding?
Yes, we do disagree with that.
Right. This might take a bit longer than I thought. What about the traffic and transportation chapter? Same question.
We do have to disagree. We do believe there is significant impact.
And what about the air quality chapter?
No, we don't have an issue.
And the noise chapter?
Ultimately, it would be a no. There are concerns raised in the in-principle application, but they could be dealt with through further details in a detailed application and further noise survey work.
So just to conclude that before I go to the appellant's side, your evidence to me is that the council does not agree that the findings of not significance in the built heritage, town and landscape visual impact and traffic and transportation structures are not significant. It's your position that actually the environmental impacts are significant. Have I got you right? I appreciate you have detailed concerns, which we'll talk on, but there's a difference between having detailed concerns and overall finding that there is a significant environmental impact.
In terms of built heritage and the town and landscape visual impact assessment, these are things that could be dealt with. But in terms of traffic and transport, no, we remain to have significant concerns. Or the significant impact.
You're changing some of the things you're telling me. Now that's okay, but you're confusing the reporter. For the appellant, any thoughts or comments?
Well, yes, sir. This underlies why I raised the initial question, because with respect to the council, their answers appear to be made on the hoof. In CD 2.3, which is the officer's report into the planning permission in principle application, paragraph 103, in respect of built heritage, having set out the ES position and then the HES position in preceding paragraphs, the council only goes this far. It says it is considered the indicative layout has the potential for a greater impact. So coming nowhere close to suggestion of a significant impact. They say that the building is of significant sensitivity, but not that the impact is sensitive. In terms of the full application, the relevant paragraphs in CD 2.4 are paragraphs 96 and 97, where it would appear to be that they agree with the environmental statement that there would be a moderate impact on built heritage, which would not be significant. So there does seem to be a significant change of position, or a material change of position, depending on which answer of Mr. Callan's you have regard to. Likewise, in terms of town and landscape visual impact, there is, with respect, nothing in the reports which suggests that it has reached the significant stage. And the further concern we have is that there seems to be a, unlike noise where concerns were considered to be capable of being overcome by condition, no regard seems to have been had to that in respect of the other, leaving aside traffic, townscape and landscape visual impact. For instance, it's been made clear that the wall can be retained and that the indicative areas of housing are indeed indicative. We are unclear as to the Council's case, and in our view that stems from the decision-making process which appears to be continuing.
Council want to come back on any of that?
Whilst they're doing, I should add that there was one issue of concern raised in respect to the environmental statement, which was bats, but as you're aware, I think that's now gone.
We don't feel we have anything that we can actually add at this stage, other than to confirm that the bats in terms of the species protection plan is considered satisfactory.
Community Council, any thoughts or comments on what you've heard?
What our position is with regard to these bullet points and the discussion that has taken place is that there are areas where we disagree with the information provided in the EIS, and we believe that it is of significant importance. And there's a particular relate to the built heritage, and in particular the aspects of the listed wall, the town and landscape visual impact, and most certainly the traffic and transportation. And we disagree with Perth and Ross Council's views on air quality. There's no particular view on noise. Having said, may I ask a question at this point for clarification as to whether the noise refers to the constructed state of should the developments take place, or the construction stage?
My understanding was the environmental impact assessment looked at both, and it made findings on both. The reason I asked the question of the council is that there was a memo from their department which raised, Environmental Health Department, which raised issues about noise from the hospital and its relationship with new housing. I don't want us to get into the detail of these things. I didn't anticipate this being quite so difficult. I don't want to waste any more time on this. I am going to reflect on the answers. I think I may well be coming back and asking the council to think about this in a bit more detail. I do think I need to have your position as to the significance. And I don't want to be unfair to you if you've been caught out and don't have a chance to refer to the actual document itself. So I'm going to put that in a black box, and we'll come back to it at some appropriate point. Can I now turn on to the next bullet point? If I can start with the appellant, you'll be familiar that typically in our decisions, if we were minded to grant planning permission, we would give brief reasoning for the conditions we were imposing. Is that sufficient in relation to Regulation 29, or is there new things that we have to look at?
Sir, I would just observe that the new regulations make more explicit references to decisions including any mitigation measures and environmental conditions, which should carry through various different consents. So there's now more explicit reference within that section to ensure that the various obligations are fulfilled and indeed in any subsequent applications for matters specified in condition as well. So it's more just to point out too that clearly within the EIA there is a schedule of mitigation at the back end of the document, which has gone on to inform some of the suggested conditions should you be minded to approve the applications.
Would you distinguish? Is there a hierarchy in your view between kind of mitigation measures, conditions, other things, or for the purposes of my decision, for all practical purposes, aren't mitigation and monitoring planning conditions for my purposes, or would you see there's difference there?
I wouldn't see a difference necessarily, as you suggest. I think that ultimately the mitigations would ultimately inform the conditions, and certainly in the draft schedule of conditions that we have in circulation, it does make explicit reference to that schedule within the EIA in itself forming a condition of any planning permission.
Add to that from a legal perspective. Obviously one has to be very careful with the EIA issues, which is why we're asking these questions. One has to have regard to what the scheme is, first of all, and if the scheme is so altered to, say, for instance, exclude any works to the boundary wall, which is an issue of contention, which is what the appellants have offered, then arguably that's not a mitigation measure, that is altering the nature of the scheme. Mitigation measures are taking the scheme as it is and then mitigating it. And monitoring measures are conceptually different again, but they are, as Mr. Littlejohn has just said, all likely to be encapsulated within conditions. Again, in our view, in terms of the description of the mitigating measures, again, could be incorporated by reference to the schedule, primarily in the EA, subject to any changes that you consider are appropriate. Likewise, the monitoring measures. But I would caution against treating them all identically from a legal perspective. I think, without seeking to unduly muddy the clarity of Mr. Littlejohn's statement, I think it's important to bear in mind the three concepts of what the scheme is, what the mitigation measures are in respect to it, and what the monitoring measures are in respect of it, because they are dealt with separately.
Thank you. Is there anything else we need to discuss about the 2000 and 17 EIA regs. We done? Okay. Can I start with the Community Council this time? Any points about the legal framework in relation to air quality you think I should be aware of?
As you know, sir, our witness, potential witness on the team was unavailable to join us. We have submitted a statement on her behalf, and that, I think, is the sum total of our input on this one.
Thank you. Council.
The other thing to add in terms of air quality is we have an LDP policy and also an LDP2, an emerging policy. In terms of environmental health, they do have their own legislation, one of those being the Environmental Protection Scotland / Royal Town Planning Institute guidance, delivering cleaner air for Scotland, which they take into cognizance in their assessment of impact on air quality, plus various other technical guidance documents.
Okay. Appellant, any thoughts or comments on what you heard?
Just to add, sir, that the EIA was clearly scoped with Perth and Ross Council, and at Appendix 10, the air quality assessment considers the context within which applications should be considered.
Okay, anything else on agenda item 2? Have we sorted out the law? Okay, I think actually now is probably an appropriate time to take the mid-morning break before we roll our sleeves up and get into the local development plan. So if we can come back for 11:30 and we will resume on item 3. BT coming? Right, we're on item 3, assessment of the proposal against the relevant provisions of TAY Plan and the Perth and Kinross Local Development Plan. The law requires me to determine the application in accordance with the provisions of the development plan unless material considerations indicate otherwise. It's therefore very important that I understand the party's position in relation to the development plan. So how this is structured, this section is structured, is that first of all I ask for parties' comments on the strategy and objectives. Then we look at the individual documents and the individual policies within those documents. And then at the end I give the parties an opportunity to tell me the overall conclusions that they wish me to take from the provisions of the development plan. So that's how it's structured. I know there's an awful lot of bullet points. That's because there's a lot of policies that people mention to me, but hopefully with a brisk canter we can get through things expeditiously. So if I can start with the council. What would you say were the strategy and objectives of the development plan?
The strategy and objectives of the development plan is in relation to delivering of development in appropriate places and having regard to social, environmental and economic impacts on a particular area.
Appellant?
Nothing further, sir, particularly from our perspective, with the exception of directing development to key settlements.
So you wouldn't take issue with the council's characterisation there?
No.
For the Community Council, any thoughts? No? So if we now move on to TAY plan, can I start with the council? I can see how TAY plan sets the strategic context within which the LDP is prepared, but does it independently provide any guidance on an individual planning application, do you think?
It complements and provides a guidance to our local development plan. It does have some specific policies, in particular policy 1, which is location priorities, and declares that Perth is a tier 1 settlement, and the majority of development within the Perth Kinross boundary should be focused within Perth itself. It also has policy in relation to developer contributions, which is policy 6. Also policy 2, shaping better quality places, and policy 10, which talks about infrastructure in particular, and that gives relationship to the infrastructure development of the cross-tailing road.
Thank you. We'll have a look at the policies in a minute. The appellant, any thoughts or comments?
Just some additional policies that you may wish to take cognizance of. Policy 2 in relation to shaping better quality places, and policy 4 in relation to housing, which seeks to identify land which is effective or expected to become effective.
In terms of the key point I made to the council there, do you think we'll look at those policies in a minute, but and I can see how they provide a framework for the LDP, but do you think they give any guidance to an individual planning application? Would you agree with the council there?
We would agree with the council in that respect. TAY plan's obviously providing a framework within which the LDP will sit, and the LDP will provide more site-specific. There's certainly points within, I think, TAY plan that are of relevance to the site in particular over other policies.
Okay, thank you. Community Council? Any thoughts? Okay. So for the council, you listed some policies there, as did the appellant. Can we just take a look at some of those? You mentioned policy 2, I think. Just bear with me. No, policy 1, I think, was your first one. I apologise. So in terms of the two proposals before me, it's a very lengthy policy. Is it just the tiers, the spatial strategy they're setting out there, the settlement hierarchy, or is there any other guidance within that relating to this particular proposal, these two particular proposals?
It's principally the section related to the tiers in that the proposals are within the Perth settled boundary. Perth is classified as a Tier 1 settlement.
Okay. Right. I think you also mentioned Policy 2. So what would you direct me to in Policy 2? Again, it's a fairly lengthy policy. Oh, sorry, before you answer that. And do you see any tensions with Policy 1 and the proposal?
No.
So for Policy 2?
First two elements in terms of place-led, in terms of layout and design, and then active and healthy by design, which talks about new development being integrated with infrastructure.
And do you see any tensions with that policy?
No. But it is mainly the LDP policies.
At Policy 4, would you agree Policy 4 is relevant?
Insofar as the council are required to produce housing needs demand assessment and guidance that we look to see sites being allocated for development. This is the policy on developer contributions. It is relevant to both proposals, and yes, we have supplementary guidance within our LTP to follow on from that.
So, do you see any tensions with Policy 6 and the proposals?
We don't. The relevance of this to this appeal is that there is specific reference made to strategic transport projects, regional transport strategies covering the Tay-Plan area, and one of those projects and strategies has been the Cross-Tay-Link Road. It's a very high-level policy. The main emphasis is actually on the local development plan and the other transport projects and strategies.
Right. To summarise, you've identified Policy 1, 2, 4, 6 and 10 as relevant, but you don't see any difficulty with either proposals complying with those policies?
In principle, no.
And for the appellant, any thoughts or comments on that? Would you agree with that assessment?
Yes, sir. No additional comments. We would agree with the position.
And is that the full set of relevant policies?
Yes, sir, from our perspective.
Okay, thank you. Community Council, Any? Okay. Right, thank you.
No comments.
Can we move on to C? And obviously I structured this by breaking it down and respecting the structure of the local development plan and going through the key policy headings. But if you just bear with me, whilst I find the local development plan. Yes. Right, if I can start with the council, policy PM1 is broken down into A and B. Do you see any tensions with the proposals before me and the criteria set out in either 1A or 1B?
We do see some tensions.
And what would those be?
In particular, criteria C, design and density should complement the surroundings. And G as well, in terms of existing building structures and natural features, contribute to the local landscape to be retained and integrated into the proposals.
Okay, so you see tensions. Would you go so far as to say the proposals don't comply with that?
Yeah, there are very broad policies, and there are other policies within the LDP that have raised concerns for us, but there is some tension with some of the criteria, in particular the in-principle application.
So you've just picked out two criteria from PM1B, where you say there's tensions for the planning permission in principle, but you're not making the argument that the proposal doesn't comply with that policy.
No, we're not saying that it doesn't comply. We have got concerns with some elements.
Your appellants, any thoughts or comments on that?
Just to observe from the appellant's perspective, we're of the view that the proposed development would comply with this policy. Clearly, the application for the in-principle element of the site is exactly that, and we're of the view that these various criteria can be met by the use of planning conditions and through detailed master planning.
Okay, Community Council?
I don't think we have anything to add to Perth and Ross's statement.
And if we turn to PM2, that in essence is looking for design statements. Is it your view that this policy has been complied with?
Design and access statement has been submitted with the proposals, so on that basis it has been assessed and it does comply with the policy.
You can just nod. I take it that you would agree with that. Yes. Okay. If we can move on to PM3. And I'll start with the council, and I'm thinking initially of the Planning Permission in principle. If I've understood from your hearing statements correctly, it's your position that developer contributions are required for the planning permission in, application, but the council believes that that is something that could be dealt with by conditions and a planning obligation at the matters specified in conditions stage. If I've got that right, would you say that for that application it complies with PM3?
I would agree with that.
But we will discuss this, I'm sure, later on. But now turning to the detailed application, my understanding is that you also say that a planning obligation is required for that application. Have you considered the viability of the proposal at all with those obligations, as is mentioned in the policy?
We do believe that the developer contributions are required and to be delivered through a Section 75 agreement. In terms of the viability, we haven't received a justification to move from a particular policy position.
So am I right in thinking your position is that the detailed application would not comply with policy PM3 as it currently stands?
On the face of it, yes.
For the appellant, any thoughts or comment?
Just in relation to the application for planning permission in principle, just to confirm that our position reflects that of the council in terms of the legal agreements that may be sought in that respect. In relation to the application for planning permission in relation to the main building, certainly in the nature of the discussions that we have been having with the local authority from the inception of the project, it's been made quite clear that the viability of the development is a significant issue for the site as a whole, and ultimately it does not stack up to have further obligations sitting against the refurbishment of the Category A listed building. In discussions, we have been fairly clear with the council in that respect, and understood that there would be an opportunity to continue that discussion. I should say that we haven't been asked at any stage to provide any detailed viability information to the council, on the understanding that the works associated with the refurbishment of the main building were such that it was quite clear that there would need to be some facilitating development to allow for that to happen.
But it's me making the decision now. I've got policy PM3 in front of me, and it says the council will consider the economic viability of proposals. So I've got to consider that. Where before me is your viability assessment?
There is no viability assessment submitted in the context of the application, sir. However, policy PM3 does allow for infrastructure contributions and the provision that where contributions are reasonably related to scale and nature of the development. So I would suggest that there is an opportunity for you to take your own view in terms of the building, the works that are required to facilitate the refurbishment, and the consequential requirement or not for additional contributions. As I say, we've made it reasonably clear throughout discussions with the Council that the costs associated with the refurbishment of the principal building are such that we don't consider it to be appropriate to seek any developer contributions. That said, the appellants would fully accept a full suite of developer contributions as suggested by the Council's developer obligation team in relation to the application for planning permission in principle.
Okay, right. Well, let's put the planning permission in principle to one side, and we can talk about the detail at our obligations and conditions hearing session. I just want to nail down the issue of infrastructure contributions for PM3. So there's no viability assessment. Why should I set aside any requirement for planning contributions then for the detailed proposal?
So that there is no detailed viability assessment. You have the evidence from via Mr. Littlejohn and the environmental statement that it is not viable. You have the evidence that from Mr. Littlejohn that there's been no request for that to be substantiated, and you have, we would say that looking at the state of the building as you have done, it's not a case which calls for that to be questioned, and it hasn't been questioned up until now, so that if a detailed viability assessment is needed prior to determining contributions, that's a matter you can request, but in our submission there's no basis upon which a request should be made at this stage, although it is ultimately a matter for you. As Mr. Littlejohn has said, the assertion has been made from the outset, and whilst you indeed are now the decision maker in respect of PM3, that doesn't mean with respect that you should ignore the interaction between the parties that has gone before.
I would just add in that respect that clearly, as the site visit will have highlighted, this is a particularly challenging project, including in relation to the main listed buildings and some of the outlying buildings as well that have been subject to fairly significant vandalism. We've obviously submitted updates to the inquiry in terms of the condition of the building, and it's fairly evident that there will be a significant conservation deficit associated with how ultimately the proposals may come forward. And there have been discussions with the Council about the acceptability of longer-term maintenance arrangements across the rest of the site, which has ultimately been set in the context of the requirement for a scale of enabling development, and there is some flexibility as to what that scale might be to ultimately allow for a sympathetic development to come forward. I think there is an issue as well in terms of the presentation of financial information. As you can appreciate, sir, the issue changes at the site almost on a, or sorry, the position changes at the site almost on a weekly basis as the appellants seek to try and manage the existing estate, and there would be some concern about presenting information which could pretty quickly be out of date.
Okay, Council wants to come back on any of those points?
I think we have to take a little bit of difference on the alleged factual information. At the outset, my understanding from Mr. Callan is there was no direct linking of the listed building and the new building that was required. Later on, there were general comments, that's true. But to say that we didn't request it, I think the onus is on the applicant to put this forward? And I think the answer, sir, is in the Developer Contributions Guide. Developer Contributions to Affordable Housing, September 2016, and it's paragraph 318. And that refers to developers expected to take requirement of developer contributions to affordable housing into account for financial appraisal and purchase of development sites. But it does go on to say, it's to acknowledge that in some cases may be abnormal development costs, which were unknown at the time the site was purchased. Other examples may be where the proposal is for the refurbishment of an important building which the council would wish to see retained or used, but the cost of the refurbishment works are prohibitive. Now, and the next bit is the critical bit. In such circumstances where the developer can demonstrate and clearly justify that there are exceptional costs, unknown when the initial offer of purchase was made, which render the development of the site unviable as originally proposed, the council will consider the strategic priorities for a site holistically when determining an application. Now, the council position there is we have not received anything. The first proper indication was actually, I think, Mr Littlejohn's hearing statement, where the claim was made not to have contributions on the FLM. So we haven't received anything. So I think for that leave answer is it's for you, and looking at supplementary guidance, it would appear that to satisfy you, they have to provide a proper detailed viability statement, and I would suggest that's not just for the listed building but for the new build as well. It's looking at it holistically, and that would allow you to, if you deem it appropriate, if you wish to request it, then it would be requesting that, perhaps having comment from all parties as well, and then you would be able to take a decision on that. But from the council position, the first proper notification is Mr Littlejohn's hearing statement, so I think the onus switches on to them to actually justify it. Sorry, sir, I should add in terms of concerns about the commercial position, we don't see a great deal of difficulty there in the sense of information would have to be presented. In terms of changing day to day, that may not be significant in terms of the overall site. We do not commonly get these requests, but when they are put in from a council perspective, when it be your decision of course, is we do look for the developer viability statement as a whole.
Come back to the appellants in a minute for a final say. Community Council, any thoughts on this? Appellants, before we move on, any concluding points you'd like to make?
Sir, thank you. I would just dispute the point that the information presented in the hearing statement is almost perceived to be quite new information. The refurbishment of the main listed buildings across the site has always been intrinsically linked to the broader master plan approach, which ultimately gave rise in the first instance to the suggestion that we take forward a hybrid application, which would allow for the building to be refurbished before any new development ultimately take place across the site. And within that conversation that the council have been privy to with Historic Environment Scotland as well, there's always been the perception that there's quite a challenge in itself in refurbishing, particularly the main building. I think certainly in terms of my recollection of the initial discussions, and notwithstanding the response that we have had formally from the Council's developer obligation team, that there were conversations along the lines that the refurbishment of the main building would not necessarily attract contributions along with the rest of the site.
So perhaps I can add to that in terms of policy PM3 itself, as you'll have noted, it doesn't require any particular type of analysis. It just says the council will consider the economic viability of proposals alongside the options of phasing. The economic viability of this proposal has been made clear. The submission that the council now say that they would look for a development viability of the site as a whole, taking into account both options, is another example of developing their case on the hoof. That is the first time that request has been suggested, and had that been indeed runs counter to their idea, their suggestion that the applications be split, and we'll deal with the supplementary planning guidance when we get to that part of your agenda, but we don't accept that the council or that there's been any request for a detailed development appraisal, because both sides have adopted the common sense view, having looked at the dwellings, having looked at the state of the current building, which is deteriorating, as Mr. Littlejohn has said, that to require infrastructure contributions on top of the safeguarding of the listed building would be unrealistic. And to the extent that the council's view has hardened at this inquiry, that is to be seen for what it is.
Okay, can I just make sure I understand the appellant's position? That there's agreement between you and the council that the planning permission in principle is subject to planning obligations. We've heard what the council said. Your position is that the proposal does comply with policy PM3 because it's self-evident that there's an economic viability issue.
In effect, yes, and that the council, that paragraph 4 of policy PM3 gives the council the flexibility to react to the situation, as the case may be, as to what the viability issue is. So I think I can say that different cases will give rise to different considerations, as we're well aware from the case of Loudon Castle. But there will be some cases where the extent of enabling development is a hotly contentious issue, but that's not this case. There's been no suggestion by the council that the number of units proposed in the grounds of the hospital are more than is required or more than is appropriate. There's been no suggestion to date that the the council wished to delve any deeper into the economic viability of the proposal than they have done until today. And so yes, sir, the way you put it is correct, but with that caveat in terms of the last part of PM3, giving the council considerable flexibility as to the extent to which it wishes to examine the issue.
No doubt we'll come back to this on some of the other policies and the SG, and of course we're having a separate session on obligations. But so my black box is getting bigger. We'll put another one back in the box. Can we now move on to D, residential development? Can I start with the council policy RD1? Is this policy directly relevant? It reads to me as if it's more about protecting residential amenity.
What it means for the council is a development must be compatible with the area, and the primary use within the area is residential.
So it's relevant, but again, you don't see any difficulty with the proposal complying?
No, I don't see any substantial difficulty in complying with the policy.
I take it the appellant wouldn't take any issue with that? Okay. Can we move on to RD4? Let's try and split this one up. So for the appellant, am I right in thinking that you agree with the council that for the planning permission in principle, the affordability policy would apply? When it comes to the detailed permission, is it your position that on the face of the policy, affordable housing would be required, but in practical terms, for the reasons we've just discussed, it wouldn't be viable, so it would not be a sensible thing to insist upon. Have I captured that right?
Sir, just to add on that point, that in early discussions with some registered social landlords, in respect of the site as a whole, it was fairly quickly determined that given the costs associated with the space to be created within the new or refurbished main building, that would not equate to something that they could afford. And similarly, there would be a difficulty in those units within any main listed building refurbishment actually meeting the standards required by the RSLs.
Right, we'll come back to that in a minute. I'm just making sure I understand the parties' positions on the principle. So again, for the council, council, any thoughts or comments on what you just heard?
Maybe need clarification. We may not have heard properly, but my understanding Mr. Littlejohn was asked to initially comment on the IPM. And our understanding is they don't take any issue with affordable housing contribution on the IPM. The issue is with the FLM. And I may have misheard, but I think he said no, there wasn't. There is an issue on the IPM. Are you now not wanting affordable housing?
No.
Sorry, I shouldn't be asking.
I think that we'll come into the detail of how things are actually going to be provided. I was starting off with just the principle of whether it's required.
Yes.
I put a summarised position. My take is that the appellant team accept that for the planning permission in principle, affordable housing requirement applies. It wouldn't apply to the detailed proposal because of the viability point that we've just been discussing. So any thoughts or comments on that?
I think taking it at a high level, I think the council's position is it does apply to both, but of course we now have the situation where the developer is requesting and it no longer applies to the FLM, and that comes back to previous discussions when we were talking about the developer contribution. Council position is it does apply to both.
Okay, I've recorded your difference. In terms of the planning permission in principle for the appellant's team, in terms of that application, what are your thoughts on how you would actually meet the affordable housing requirement?
Sir, certainly in discussions with the appellant, the intention would be that the provision would be provided on site in relation to the PPP.
And there are many different forms of affordable housing. Have you developed how that would work? Is it would be with a...
Sir, not at this stage. Clearly the requirement or the application is for up to 70 units. That will ultimately be determined, should you be minded to grant consent, by a detailed master plan, which in itself would give rise to a discussion about the nature and scale of affordable housing on site. But certainly the intention would be that affordable housing component is provided on site.
Council, any thoughts or comments on that?
We would agree that the affordable housing required on site, and that would fall in line with our policy and our supplementary guidance on affordable housing in terms of on-site provision, whether it be through the developer themselves, resident social landlord, or indeed the council actually delivering the affordable housing.
Just generally, in your experience applying this policy, does Perth and Kinross consistently require affordable housing contributions for involving listed buildings? Would it not always raise very ticklish issues with social housing providers?
It can do, and it goes back to the argument over developer contributions in terms of any justification to depart from council policy. Reserved matters AMSC stage would also take account of that as well.
Okay, anything else we need to discuss on policy RD4? We done? Any other residential development policies that I may have overlooked? We ticked all the relevant ones? Okay, can we turn to the transport policy? See if I can take this in one go. If I can start with the council, TA 1A and TA 1B, quite a long policy. Is there any particular aspect that you would argue the proposal doesn't comply with?
It's in the middle section of policy TA 1B. In certain circumstances, developers may be required to prepare transport assessments and implement appropriate mitigation measures where required. And further down again, C, it would not have a detrimental effect on the capacity or safety of the strategic road and or rail network.
So a developer is required to provide a TA, which has been done in this case. So it's C. It's your position that the proposal would have a detrimental effect, which is the harmful thing.
Yeah, our position is that it hasn't been properly assessed.
If you can think about the general case as opposed to this particular proposal, how should I interpret the word detrimental effect? Is that any detriment, or is there a particular threshold? Does it apply just to a junction, the whole system, the peak periods? How can I understand the policy test of detrimental effect?
It's difficult to depart from each individual application because everyone is assessed in its own facts and circumstances. But I think in this, trying to avoid this particular one, but it's no net detrimental impact on the junction.
Community Council, any thoughts on this policy?
think we see this as important and key. I think the concept of detrimental is certainly important in various aspects that would include certainly health and safety. It would include the impact, commercial impact, if you like, on traffic, both private and commercial. So there are very wide-ranging applications here, or implications rather, that need to be reviewed, and that is certainly our perspective.
Appellant, any thoughts or comments?
So in two stages, first from me and then from Mr. Littlejohn. So in terms of the criteria to produce a transport assessment, you may not have seen it yet, but in paragraph 22 of the draft SOAM, in response to the assertion that the TA was undertaken in accordance with the guidance, the answer by Perth and Kinross is that is technically correct, that the interpretation of the outputs that's at issue, which is akin to what one might have in a wind farm inquiry on a LVIA. The assessment may have been done in accordance with the guidelines for landscape and visual impact assessment, but the parties may disagree over the outputs. So that, notwithstanding the Council's position, it would seem clear that they accept there has been a transport assessment. It's the disagreement over the outputs that's the issue, which comes to C. And whilst the Community Council raised the issue of safety, just ask to note that the Council's position appears to be a capacity issue, not a safety issue. And with that, I'll pass over to Mr. Littlejohn.
Just in terms of the transport assessment which was submitted in support of the application, and clearly will be a matter of debate tomorrow, I suspect, the appellant's position is that there will be no net detriment on the junctions. I would also add, I think, picking up on a point about travel planning, I think, from the Council, that both the TA, air quality and environmental impact assessments submitted in support of the application included references to travel plan frameworking as part of the mitigations associated with the developments.
Okay, I think we're going to have 2 days of discussing this, but so I won't get into the detail. I've recorded your position on the policy. Anything else on transport standards and accessibility? Are we done? Okay, if we can now go to the F and the community facilities suite of policies. If I can start with CF1A. As I understand it from your hearing, and I'll start with the Council, from your hearing statement, there's the street side of the wall at the site is shown on the proposals map for open space. Does that, in your view, mean that any incursion would breach the policy?
It's certainly shown in the current plan to be open space, and any incursion into that area beyond the boundary wall is a significant concern for us.
Again, you used the word significant concern, but would you go so far as to say the proposal before me does not comply with policy CF1A?
It's not so much that it doesn't comply, because it is an indicative plan. We would, if you were, for example, minded to approve, we would seek that no development at the detail stage would be beyond the boundary wall and encroaching into open space.
Thank you. Appellants, any thoughts or comments?
Just to confirm, sir, that in the various statements before you, the appellants have detailed that they would intend on restricting development on what I term in my hearing statement to be the western flank of the site, which is effectively that identified as open space on the local development plan proposals map opposite the Millennium Park. So development would be solely restricted within the boundary wall.
Okay, thank you. Council, any thought?
Nothing to add other than we agree with the local authorities' comments.
Let's see if we can do this in short order. So for the council, what would be your position on policy CF2 and policy CF3? Do both proposals comply with those two policies?
Provided there is no impact on the access to the adjacent core path and for people to be able to use that within the community, and there shouldn't be any implication.
Appellants, agree with that?
We do, sir. Just to add that I think the policy in relation to public access, and in particular the benefits that the proposed development can bring to enhance access to the core path, should be noted.
We'll talk about that at the design session. Anything else we need to discuss on the community facilities, sport and recreation policy? Are we done? Okay, historic environment. If I can start with the council on policy HE2. What is your position on the detailed application in relation to policy HE2?
We don't have a particular issue with the detailed application in terms of the principle of the conversion to residential is acceptable to the council.
And in relation to the chapel, in a situation like that, would you not need some comfort that a future use would be secured before you granted consent?
Whilst the chapel is inside the red line and the application boundary, no use has been proposed. It has been suggested that it will be used as a site office during construction. We would expect a further application specifically for the change of use at a later date.
Okay, I'll just stick with the council and come back to the appellant in a minute. And what's your position on the planning permission in principle then?
The principal position is there are a number of aspects. The citing of the indicative proposal in terms of impact on the boundary wall. Also, there is a shared concern between ourselves and Historic Environment Scotland in terms of some housing rear gardens right onto the boundary of the wall, and something that wouldn't be acceptable from a design and placemaking aspect as well. And overall, it's just the impact of the development or what it would have on the setting of the listed buildings.
understood that from your hearing statement, and we'll get into that at the design hearing session. How can you apply policy HE2 to an illustrative scheme?
Simply because it's the only scheme that we have in front of us at the moment in which to base any level of assessment.
Okay, thank you. Appellant, any thoughts or comments on that?
Sir, not necessarily in relation to the actual policy references themselves, but in respect of the chapel, the discussions have been ongoing, obviously, in that respect. Clearly, there's no detailed proposals at this stage. However, the expectation would be that the site as a whole would be factored, and ultimately that the chapel would be retained as part of that broader factoring and management arrangement. And it may be that there could be references and conditions to future management of that space and going forward, although I would agree with the Council and Mr Callan that ultimately any changes of use or changes to the building in its own right would require applications for listed building consent and planning permission separately.
My reason I asked that question was more about if you have a proposal for a group of listed buildings and one is left out, would you not want to, before the developer left the site, would you not want to make sure everything had been secured, that you weren't leaving something behind without a use? You're saying that won't happen?
I think that's our position. I mean, ultimately at this stage in the process, the chapel is a very important part of the overall site, and the appellant's approach thus far has been to retain the chapel and keep it in a good state of repair with the heating on and such like. Ultimately, we are envisaging a fairly lengthy refurbishment process on site, and in that context, I actually think that it is probably right for the chapel to remain in sort of the collective ownership, if you like, in going forward until such a time as a future use is secured.
And I think I stopped you. You were going to tell me about policy EH2.
Yeah, sorry. Just in that respect, I think our view is that, agreeing with the points that Mr Callan has ultimately made, that we have support, obviously, from Historic Environment Scotland for the approach that we're taking. And I think with the references already this morning to our intention to restrict development on certain parts of the site, including in and around the boundary wall, which the Council have determined to be listed by curtilage, we begin to fall very much in line with that policy.
If I could summarise my understanding, for the reasons that no doubt we'll discuss during the design hearing session, subject to appropriate conditions that would influence the matter specified in conditions application that would follow on, you're confident that both proposals comply with EH2. Is that fair?
Yes, certainly, sir. That's fair.
Okay. Community Council, any thoughts?
Yes, our concern or question, perhaps, is a better way to put it with regard to this discussion and what we've heard from Mr Littlejohn really concerns the future ownership of the chapel, and we're not clear how that plays out in this scenario.
Well, I understood Mr Littlejohn's answer that there would be some kind of factoring arrangement. I think we're going to discuss this in more detail at the obligations and planning conditions, as well as the design hearing session. Is there anything else we need to discuss about historic environment policies? We done? Okay. If we can now look at the natural environment, and looking at policies any 2A and 2B, again, if I can ask the Council, how can you apply these policies to an indicative layout?
Largely similar to the historic environment one, and in principle, the plans show an impact or potential impact on trees, and in particular, there are 30 trees within the site that have tree preservation orders on them, and some of those trees have shown to potentially to have an impact on them.
Just ask you to look in detail at 2A and 2B. What particular, because again they're quite wide-ranging. It's quite a wide-ranging policy covering various elements. What particular areas do you feel there's tensions?
As it stands, there's tension between policy NE2A criteria B, which is protect existing trees and woodlands, especially those with a high natural, historic and cultural heritage value. Also to criteria E, ensures protection and good management of amenity trees and safeguard trees on development sites in accordance with the BS 5837, which is trees in relation to construction.
And what about 2B?
There is a tree survey has been submitted with the application, and the Forestry Commission Scotland have said in their response that any woodland removed would need to be replaced.
Okay. So I take it for the detailed proposal there's no tension with any 2A or 2B. Is it your position that the planning permission in principle would be contrary to both?
It's the in principle application. There is some level of tension there with protection of existing mature trees, and particularly those ones with a tree preservation order on them.
You're using the same formula that you have a level of concern or level of tension, but would you go so far as to say there is a breach of the policy?
Based on the indicative plans, there is a breach.
Pellets, any thoughts or comments?
Thank you, sir. Just to make the comment that in relation to the policy, rather than there being any tensions as we see them within the policy context, these are very much policy considerations for you to consider in determining or considering applications in going forward. I think ultimately we take the view that the illustrative layout is exactly that, and we've seen in the draft conditions that have been passing between ourselves and the council that there are ways and means which the future protection of trees can be considered through a detailed master planning exercise in going forward. I think from the appellant's perspective, just to clarify, one of the intrinsic areas of value across the site is the trees and the protection of trees, and certainly our position has always been that we would be looking to develop the site sympathetically within various landscape zones with very limited impact on trees. Clearly the information submitted to the Council on the PPP is illustrative at this stage, and a suite of additional information, including in relation to tree protection, will be submitted. We would suggest that the matter specified in condition stage. I would go on in terms of the detailed application to make the point that there's very little impact on trees associated with the refurbishment of the main hospital building, perhaps with the exception of some works to landscape areas on the eastern and western flanks of the existing former Murray Royal site, where we're proposing areas of car parking within the existing exercise yards. And just on point NE2B, I think, as you suggested, a tree survey was submitted with the application.
Okay, thank you. Community Council, any thoughts or comments?
No comments at this stage.
Anything on policy NE3 we need to discuss? No? Are we anything else on natural environment policies? Okay. Can we now look at the suite of policies under environment protection and public safety? And I'm going to have to ask the Council to help me. I'm afraid I'm not sure I understood this policy. Perhaps you can talk me through it. I got confused by the year numbers at the side. How do you, leaving aside this case, how do you apply this policy to proposals for new housing?
I would concede there's a certain level of difficulty. It is very much a building regulations requirement that has been given to planning, and all housing developments are required to hit certain standards, but that is done through the building regulations process. I believe this is a policy which is no longer is not proposed in the next LDP.
So your advice to me is that, notwithstanding it's in the LDP, I can quietly forget about it.
In essence, we've had, as a council, have had difficulty in applying it where housing developers, whether to be large, medium, or small, have to hit a certain standard in terms of their building regulations, and that is what we're requiring them to do in terms of complying with planning policy as well.
Appellant, agree that I should turn a blind eye to this policy?
I agree that the policy sits within the development plan, and Mr. Callum's provided some clarity on the Council's position in that respect. It was more just to observe that clearly any new build development across the site would require to comply with the relative or relevant building regulation requirements in terms of low and zero carbon generating technology, and elements of the main building would have to as well.
Okay. Anything from the Community Council? EP 3 for the Council. Any difficulties with the proposal? Both proposals complying with EP3?
No difficulties in terms of the flood risk assessment has been submitted and assessed by SEPA, Scottish Water, and the council structures and flooding team. I believe there is some apparatus belonging to Scottish Water within the site that may cause a development difficulty further down the line.
But for our purposes, you're not suggesting any problems with EP3 3A to D?
No.
happy with that? Committee Council? EP8. Noise. I note that the Council's Environmental Health Officer expressed a concern about potential impact from noise from the hospital itself, and noise levels within any new houses. Does that comment suggest a problem with complying with policy EP8?
I mean, in terms of the detailed application, I think it would be very much it's a buyer beware of what's your neighbouring land use, and in terms of there may be noise coming from that, and there's very little that can be done to mitigate that in terms of dealing with an A and B listed building. The concern from environmental health is in relation to the in-principle application and potential new build, and it depends on where the elevations are and how they're orientated relative to noise from the existing hospital, and that may have an impact on the finalised layout. And that would obviously be addressed during an AMSE application.
So noise levels might be a design constraint for the planning permission in principle, but your position is that there's no direct breach of the planning policy.
Certainly not at this stage.
Appellant, agree with that? Committee Council? Policy EP11. I'll start with let me find it. So for the council, what's the test involved for air quality in relation to this policy?
There must not be an adverse impact on air quality within the area, and in particular the Perth Air Quality Management Area, which the site is adjacent to, and the majority of traffic would go through that air quality management area at Bridgend.
My understanding is that certainly the Bridgend area already exceeds recommended levels. Does that mean that prevents any development?
What we're looking at is no negligible impact.
So the council's position is that the proposal would comply with policy EP11, is that right?
In principle, yes, it does.
Community Council?
I don't quite understand what Mr. Cullen said there, because we certainly are very concerned about air quality, and we do not see that the proposed development would have no net impact. No net impact would be acceptable, but we haven't seen how that is going to be achieved.
Thank you. Appellants, any thoughts or comments?
No further comments, sir, other than to just make reference to the air quality assessment that was submitted in support of the
Okay. Anything else on the environmental protection policies? We done? Can I now turn to J, the Perth area spatial strategy within the LDP? If I could start with the council, would it? Sorry.
Wasn't listed on your.
Yeah, it's policy EP12 is contaminated land. The council's land quality officer did identify that there was potential for contamination within the hospital grounds, and there was some infill ground as well, which may have some unknown quantities in it. That was something that's required or recommended by a condition to be addressed.
So your internal consultee is flagging that up. Subject to appropriate conditions, the matter could be addressed. So it's a relevant issue, but you're not suggesting that this prevents the proposal going ahead.
It's relevant, but it's not. It doesn't prevent.
Helen, agree with that? Okay. Are we done? Look around again. Yes. Okay. So we're now on the Perth area spatial strategy. And if I could start with the council. Would it be fair to categorise the Perth area spatial strategy as one of a growth strategy?
We would agree. Perth is one of the biggest growing authorities. The main focus of development is identified towards Perth, so Perth will see the largest area of expansions.
So I noted that between 2010 to 2024 there were some 7,000 houses indicated for the Perth area. Does that have any implications for the context within which I should see these two proposals?
There's no significant implications. The sites that are identified in the local development plan are, by and large, are strategic development sites, so they're very large scale, and they're the sites that are required to use the projected growth, population growth in the area.
Appellant, any thoughts or comment?
Just to comment again that the spatial strategy clearly looks to focus development within the urban area with tacit support for the development of brownfield sites.
Community Council, any thoughts? No? And if we now move on to transport infrastructure and paragraph 517, my reading of that is it says an embargo does not apply to brownfield sites in Perth. Is what you're proposing not a de facto embargo?
I'm not actually sure what you mean, sir.
Well, if we look at para 5117, I'll read it out. It says it recognises that delivering the key projects will take many years, resulting in a number of sites being constrained until the infrastructure is in place. The major constraints are to prevent the reduction in inequality and increased congestion in the Bridgend area of Perth. There will be an embargo on planning consents for housing sites of 10 or more out with Perth on the A93 and 94 corridors until such time as the construction of the Cross Tay Link Road is a committed project. The embargo will not apply to brownfield sites. So if my reading was that the embargo shouldn't apply, but the Council's position is that development should be restricted until the Cross Tay Link Road is built. Is that not a de facto embargo?
What we have been proposing has not been an embargo. What we've been looking at in terms of the resolution of the proposals is a phasing arrangement, because it is recognised that there are issues at the Bridgend Junction, and that does require still to be mitigated.
Community Council, any thoughts on that?
Yes, the Community Council has never been comfortable with that particular phrasing in the LDP, and see that it in fact is superseded by the LDP2, the proposed plan that's hopefully coming into being. The issue, I think, really is that it's the impact on traffic of this proposed application, of the two proposed applications, that is the issue, rather than arguing about the brownfield site part of it.
Appellant, any thoughts or comments?
So just two. Firstly, that the paragraph talks about until the CTLR is a committed project. And our understanding is that the approach being taken in the emerging development plan is that the report has been told that it should be treated as committed by 2021. The second point is that Mr. Callan's answer about phasing is effectively trying to sidestep the point. It is a embargo by imposing a phasing condition, which it would effectively reach exactly the same impact as the embargo here. So you may call it by a different name, but in essence the Council is seeking to impose an embargo until the CTLR is committed.
Would you go so far as to say that that position is incompatible with what is written down in the LDP?
The embargo is negatively worded, so I'd like to reflect on my answer to that and put it in my closing submissions if possible, because it's tempting to say yes, but I think just because the embargo is a negatively worded embargo, it's not necessarily giving encouragement for anything that's not covered by the embargo. So I think I would need to phrase my answer to that carefully.
We'll leave it at that. We'll just go around again. Council, do you want to come back on any of those points?
No, I think the position as was stated earlier.
Community Council, anything to add before we move on?
I just think it would be good to have some clarity on where we are on the LDP regarding the Crossdale Link Road. There is some conflict as far as the community councils are concerned between the wording. The initial wording we believe in the plan was that traffic, development would be allowed when the bridge was completed. Now, there's quite a big difference in time between committed and completed. I gather there's some movement to get the word changed from completed to committed. The difference could be 3 years, and that's a very, very large amount of traffic pollution. And we would certainly like clarity on what this really means. We have always assumed that it should be completed, not committed.
Well, no doubt we'll move on to that. But my reading of this particular section is it does use the word committed.
The initial plan that we reviewed had completed, and we requested that was retained, and we still understand this is under discussion.
Right, we're now on LDP. We'll come on to LPT2 in a minute, and maybe that's changed, but the phrase I just read out does use the word committed. In which case, Council, perhaps you can clarify. What do you, I think you gave a definition of committed in your planning obligation and conditions hearing statement. Is that the latest position?
That is the current position. The definition that we have used in terms of committed development and on other sites in relation to work before the CTLR is the contracts let, and there's actually a physical start on site.
Okay, that's answered your question. You might not agree with it, but that's the answer. Anything else we need to discuss about Perth area spatial strategy?
Can we just put a caveat down that we understood it was contract let but not necessarily start on site was the Council's position in respect of as reported to the LDP reporters. So, but we'll confirm that in due course.
Right, well, I think committed is a phrase used in several of the conditions. I'm sure we can discuss that, but it would be nice to know an authoritative answer at some point. Anything else on Perth area spatial strategy? Have we done all we need to on the LDP? Can we turn on to the statutory supplementary guidance? And we've touched upon this. Let's just see if we haven't covered it already. Okay. So let's start with the appellant, but bearing in mind what we've discussed in relation to the affordable housing policy and the developer contributions policy, what conclusions are you inviting me to draw from the statutory supplementary guidance?
Sir, I think principally, obviously, the supplementary guidance is providing further clarity on where developer contributions would be sought. I don't think there's any difference between ourselves and the Council in terms of how we deal with the application for planning permission in principle in terms of obligations, and ultimately the Council's Development Obligations Officer has responded in relation to how we might deal with that by way of planning conditions. Ultimately, I think in terms of the application for the refurbishment of the main listed buildings across the site, it was probably just to do nothing more than maybe point out references within the guidance where it does allow for a tailored approach in certain circumstances to be taken. And I think the Council already referred as well to paragraph 3.18 of the supplementary guidance when it refers to proposals for the refurbishment of important buildings.
Is it your position that it's self-evident that an exception should be made for the detailed application?
Yes, effectively so, that's our position.
And therefore, whilst the statutory I'll try to get my teeth in. Whilst the statutory supplementary guidance applies to the Planning Commission in principle, because of the self-evident viability issues, the detailed application also complies with that caveat.
Yes, I think that's the case, sir. Certainly, in concluding on paragraph 3.18, the guidance refers to the Council considering strategic priorities for a site holistically when determining an application.
And when it says Council, it now should read me. Well, I mean, so how are you comfortable in relying on the evidence that it's self-evident?
Yes, that's it's self-evident, and it's been our stated position. So you don't have the detail to back it up, but you have the stated position of the applicant's team throughout that the assessment does not stack up without with any affordable housing contribution. And I mean, effectively, I'd be repeating my answer now to policy RE4 and PM3.
Okay, thanks for that. Council, any thoughts or comments?
I think really we're referring back to earlier discussions. I think the difference here is, yes, it's now out with our hands. It's very much in your hands. And what our observations are in relation to the supplementary guidance, and particularly that paragraph, it was 3.1.8, which I referred you to. And if it was in our hands, which is not, we would be looking for the detailed justification.
Community Council, any thoughts? Okay, anything else we need to discuss about the supplementary guidance? Okay, we'll now move on to the final bit, and this is the overall conclusion. So I'll go round the parties in inviting them to let me know. We've looked at the objectives, we looked at the individual policies. What is their position over whether the proposals, both proposals, comply with the provisions of the development plan? If I could start with the Council, what's your overall conclusions that you're inviting me to draw?
The overall conclusion is the principle of development apposite is acceptable. That has never been in question. The conversion of the listed building is compliant with policy. In relation to the in-principle application, where we do have an issue, and it's obviously something which we'll come on to tomorrow, is the output and the findings of the transport assessment in terms of the impact that would have on the transport infrastructure in the area, in principle at Bridgend. There are some other concerns in relation to impact on the setting of the listed building from the principal application, and also in terms of potential tree removal within the site. There are some aspects which could be dealt with in the MSE application.
Community Council, any thoughts on the overall conclusions as to whether it complies?
very much in line with the local authority on that. We, as a community council, have long taken the position that we support housing development, we're keen for housing development and improvement in our area, but it has to be consistent with proper infrastructure provisions, and while we do have share some of the concerns that Mr. Callum has alluded to, our primary concern in this is obviously that the proposals really present an unacceptable level of detrimental impact on the traffic network, and that certainly contributes, in our view, policy TA1B.
For the appellants.
Sir, just to confirm our position that we're of the view that the proposed development complies and indeed is supported by the local development plan. Just to add to the Council's position, detailed matters in our view can be dealt with by way of planning conditions and, where necessary and justified, any legal agreement.
Okay. Are we done on the local development plan? I'm taking that as a yes. Right, I think that would be an appropriate point to take our lunch break. If we could come back for 2 o'clock, would that be okay? And we'll start on item 4, looking at Scottish Government policy and guidance. See you all back at 2 o'clock. On item 4, assessment of the proposal against Scottish Government policy, guidance and advice, Scottish planning policy, and the first bullet point, if I can start with the Council. Just thinking now of the planning permission in principle application, in your view, is that proposal an example of development that contributes to sustainable development?
Yes, provided the transport assessment is correctly assessed.
So does that mean if after Tuesday and Wednesday I was persuaded by the Council's evidence that there was an unacceptable impact, then your position would be the proposal was not sustainable development?
That is correct.
And what would be your answer for the detailed permission?
Same in relation to the transport impact.
Helen, any thoughts or comments on that? I take it you would agree with that.
Yeah, certainly from our perspective, we're of the view that the appeal proposals do represent sustainable development in the context of paragraph 29.
And for the Council, do you accept the tilted balance argument that has been put forward by the appellant in their hearing statement?
that's quite a complex legal position. I think what we can say is that considerable weight and importance can be given to it, but it's still got to be assessed in terms of permitted and refused in the ordinary sort of planning criteria. Without going into a lot of depth, I think that would be the succinct position.
I think I'm going to push you a wee bit there. So I think the appellant's position was because the local development plan is out of date, and you've just agreed, subject to the TA, that the proposal would be an example of development that contributes to sustainable development. That would be a significant material consideration that I would have to attach weight to in accordance with SPP. Would you agree with that? I thought from your statement of agreed matters that you weren't.
Well, the issue of the statement of agreed matters is one that may seem semantics at the end of the day, but we don't technically agree that the LDP is out of date as such. The SPP refers to out-of-date policies, and it refers to no policies. The critical element is the last sentence. Can you find it? The same principle should be applied to the development plan is more than 5 years old. From our perspective, yes, it is now more than 5 years. It's not out of date as such. It's now more than 5 years old. The requirement under Section 16 of the Town and County Plan of 1997 Act is to prepare, and that's not defined, but we put that in. The new LDP was put in before the expiry of the 5 years. So we've complied with the requirement under the 1997 Act. What this does is refer to significant consideration in terms of the sustainability test. Now, we will do recognise that. However, you've then come back to your traffic impact issue.
Thank you. Appellant, any thoughts or comments on that?
Yes. With respect, that answer is confusing the statutory position with the policy position. The current LDP remains the statutory plan for the purposes of the application of Section 25. There's no dispute about that. But in terms of the policy provision and the application of paragraph 33, it's wholly irrelevant whether there's a replacement plan going through the process. The last sentence of paragraph 33 is clear. The same principle applies where a development plan is more than 5 years old. Clearly that is being equated with the plan being out of date. It's a matter of semantics as to whether more than 5 years old is considered out of date or not, but the same consequence arises. There are two consequences. Firstly, if the development contributes to sustainable development, then that is a significant material consideration. And you've just turned the answers to that, so I won't continue that. The paragraph 33 goes on to say decision makers should also take into account, so that's a further point, any adverse impacts that would significantly demonstrably outweigh the benefits. And that's the tilted balance exercise. So we not only have a significant material consideration in favour of the proposal, the balancing test under policy but not under statute has been tilted, so that the test is, do the adverse impacts significantly and demonstrably outweigh the benefits? And that's what the tilted balance is, and that's been confirmed by the Inner House twice recently in Graham's Dairies and Gladwell. say that it may be helpful to Council to indicate a rough timetable for the new LDP, because by the time you come to issue your actual decision, this discussion may be historic, and I'm conscious of that.
Yes, we'll come on to that on the emerging plan. The council, do you want to come back on any of those points?
I think, as I said earlier, don't agree that it's out of date as such, but I think that's probably semantics. We do recognise paragraph 33. However, you've got the issue of, is it sustainable development in relation to the traffic impact?
Okay, Community Council, any thoughts on this?
Yes, with respect, I think we view this as a rather sad little legalistic quibble in many ways, which is looking at the perhaps letter of the law rather than the spirit of it from a layman's perspective. But I'd also point out that the LDP was in fact give the regulations which applied at the time the planning applications were actually submitted. And therefore applied.
Okay, are we done on SPP policy principles? Right, let's see if we can take some of these in short measure. The other bullet points were just the headings of policy areas that seem to me to coincide with the policies we discussed under the LDP. If I can start with the appellant, in your view, does SPP add any additional policy perspectives compared to the LDP? In other words, do you get a different answer looking at SPP compared to the LDP?
So from our perspective, I don't think that we do, with the exception of the discussion just now on paragraph 29.
Okay. Council, do you agree with that?
We do agree with that. The policies contained in TAPE and LDP are largely reflected by what's contained in the Scottish planning policy.
Okay. Community Council?
I have no comment on that.
Right, well, right, on that basis, since we've talked through all the policy areas this morning, I don't propose to go any further into SPP. Are there any, before we move on to the National Planning Framework, are there any other points we need to discuss under SPP? Are we done? Okay, National Planning Framework. For the appellants, any key points you want me to draw from the National Planning Framework, bearing in mind your particular two proposals?
So I don't think there are any particular comments over and above those which are already detailed in the SPP and then the local development plan. From our perspective, clearly the vision that's set out within the National Planning Framework, to our mind, does tick a lot of boxes in terms of the proposed development, in terms of creating high-quality, diverse and sustainable places. But generally, I think the policy principles are rolled through then into the local development plan.
Council, would you agree with that?
Yes, by and large, Perth is identified as a focus for investment in NPF3, but also relating to just a little on the vision, a successful, sustainable place. One of the tests of that successful, sustainable place would be the traffic impact.
Community Council? If we move on to other Scottish Government design and advice, looking at the various planning advice notes that have been quoted, can I start with the appellant? Are there any particular points you would draw my attention to in relation to these two proposals?
Sir, merely to observe that the documents have some relevance, obviously, in the consideration of the proposals, but given the nature of the issues at debate, they're not considered to add any additional new areas beyond those assessed in the context of the development plan.
Council, would you agree with that?
We would agree with that position.
Community Council? What I listed as a separate bullet point circulars 312, 32012 and 41998 to frame our discussion at the planning obligations and planning conditions hearing. One point I would like to pursue, perhaps I've had an unduly sheltered planning life, but I've never seen a planning obligation attached to an application for matters specified in condition. Perhaps the council, or I'll start with the council. Is that approach permitted in law and policy?
I assume it's conditions you're referring to.
Oh, in your hearing statement, well, both of you agree that it's acceptable by condition to the planning permission in principle to indicate that a planning obligation should be signed before you grant the matter specified in conditions application. And I'd be interested to know why you think that's okay in law and policy.
Well, in terms of policy, there was a requirement in the in-principle application for affordable housing, education contributions and transport infrastructure contributions. We've had a standard model condition for in-principle applications where that can be dealt with by a legal agreement at the detailed matter stage when you know your exact numbers that you were dealing with. It is merely to highlight the fact that they actually will be required in a future Section 75 legal agreement, and without reference to them in conditions, the Council would struggle to have a hook effectively to seek to request them at a further detailed application.
Further forward is, when the numbers are not known, you cannot calculate the contributions, and that presents a difficulty in putting it into a Section 75 agreement. And essentially, to my understanding, and I have to admit I don't draft Section 75 agreements, but I've seen them, is that they end up saying really the same as the conditions.
Yes, no, I see the practical issue. It's just that I always understood that the planning permission in principle was the planning permission, and that matter specified in conditions is just the detail that flows from the actual planning permission. So is there anything in law and policy you can count to? You've obviously been doing it.
It's been standard practice for a good number of years now. That hasn't been challenged. But essentially, I wouldn't say that's incompatible to what you said, in that the detail comes, there will be further discussions, and the detail comes at the MSC stage once you know the numbers and work it out there. In the meantime, what you're doing is saying that should comply with the policies.
Pat, any thoughts or comments on that?
Yeah. Firstly, I don't think there's anything in the terms of Section 75 of the Act which ties an obligation even to a permission so that you can have a Section 75 obligation which is freestanding, provided it comes within the terms of Section 75(1) to restrict, regulate the development or use of land. Neither do I think in policy terms, although I haven't double-checked the circular in the time since you've raised the question, that there's a policy requirement that that be so. And whilst it's unusual, it does happen. I think one example may be, for instance, a wind farm permission where a condition is effectively requires a bond to be produced, which is likely to be by way of a planning obligation, and so that the condition, to fulfil that condition, you will effectively need a planning obligation, so that there's, in essence, an agreement with the council it can be done.
Okay, so your advice is I need to get out more. Okay. We'll come on to the detailed wording of the council's suggested conditions in the conditions and hearings session, and we may touch on that once more. Does the Community Council have anything on the circulars? Okay. Is there anything else on Scottish Government design and advice we need to discuss? We done? I think so. Right. Move on to Historic Environment Policy for Scotland. Let's see if we can combine these two bullet points. Let's start with the appellant. Are there any particular points you would want to draw my attention to in relation to either the Historic Environment Policy for Scotland or the Managing Change guidance notes?
Sir, yes, just initially, it would perhaps be helpful just to point out one of the core documents, 1.8, which is correspondence from Historic Environment Scotland, which clarifies the principal changes, I guess, between the Historic Environment Scotland policy and now the Historic Environment Policy for Scotland, as being that they sitting under the Historic Environment Policy still follows the key principles as they always did. So we're mindful that at the time of the submission of the application, it was the Historic Environment Scotland policy document that was the policy document that Historic Environment Scotland were using, and it was to make the point that the Historic Environment Policy Scotland document follows very similar principles. But we have sought within the hearing statements to identify within that some of the sort of key policy tests, including HEP 2, HEP 3 and HEP 4, and the core principles as well.
And anything in the Managing Change notes that you want to draw my attention to?
No single points particularly, sir, with the exception of the point that some change is inevitable in the historic environment. I would add in the environment
1212.
Is that clear?
1212.
Okay, thank you. For the council, any thoughts or comments on that?
Thank you very our contribution were based on the advice and guidance from Historic Environment Scotland.
For the Community Council? Anything else on historic environment policy guidance? Are we done? Are there any other relevant guidance and advice that we need to talk about? Okay. Well, we'll move on to E, the overall conclusions, which again I'll just ask the parties I'll give them the opportunity, the overall conclusions you're asking me to draw. So if we could start with the Council. So your overall conclusions on Scottish Government policy and advice.
It's largely consistent because they are policies that are then reflected in the local development plan.
Community Council?
I don't think we have anything to add other than the comments we made about the local development plan.
Philippe Evans.
Sir, just to make further reference to the support afforded to the proposed development by the relevant material considerations, and in particular the presumption in favour of sustainable development and the point on tilted balance that we previously discussed.
Okay, thank you. Right, if we now move on to item 5, assessment of the proposal against Perth and Ross policy guidance and advice, and if we can start off with the emerging local development plan, perhaps the Council can give us an update of your understanding of the likely timescales for the publication of the examination report and possibly even adoption.
What I can say is that the DPA have a target date for publication of the examination report, which has been given as the 9th of July, just I think a couple of weeks' time. As much as I can say, my understanding is the report is being drafted. I'm not in a position to guarantee that it will be the 9th of July when it will be published, for obvious reasons, but my understanding is it is at least getting there. I'm not aware, we've not been advised of any significant delays in doing that. And I think Mr. Finlay was correct, as whatever discussions we have about it is maybe somewhat superseded in the sense that once the examination report is out, then that becomes, there is, I would agree, greater weight to be given to LDP2. Simply on the basis, and I'm being very simplistic here, it's very difficult for the Council to dispute and disagree with the conclusions in the examination report. So that therefore gives greater weight to that. But that's as much as I can say in terms of the update. The target date is the 9th of July, not that long away. As far as I understand, the report or reports are being drafted. Not aware of any significant delays, but of course, you can see.
And have you any thoughts about the timescale that the Council would then have to follow through in terms of adoption?
It's not something I've been directly involved in, but my understanding is that looking to adopt it late summer into autumn. So as frankly as quickly as possible, yes.
Just in general terms, does the new LDP represent a significant change in policy approach?
It is by and large a continuation and an update on the existing LDP. Many of the policies actually with very little change.
Appellants, any thoughts or comments on that? Would you?
Just, sir, to agree with the thoughts of the council in that respect.
Well, just thinking, yeah, I think it does look very likely that we'll get the examination report before I can issue a decision. Would it be prudent for us to have an exchange of comments once that's received, and possibly even before, which we would factor into the timetable for closing submissions? Finlay?
Yes, I think it would. After the report is received, the council then has to take a view. Then Scottish ministers have the option to delay it and call it in if they wish to. So that the timetable thereafter is uncertain. But yes, given the 8th of July stage, it would certainly, Mr. Callan is quite correct. It is essentially, in broad terms, just a continuation. There is a specific criterion to this site which is an issue of dispute, of which you'll no doubt be aware. But it would be sensible to factor in provision for submissions on that as part of closing submissions.
Well, that seems a subject for our wash-up. Would the council agree with that?
Yes.
Okay. Community Council, anything to add?
Just question the need for that unless there is any significant change.
Well, significant tends to be in the eye of the beholder. You're not obliged to comment, but it might be interesting. So I've made a note, and that's going in my black box, which we can discuss at the wash-up session. I actually did a reconversion table of the policies in the current LDP and the new LDP, and they did look very, very similar. There are one or two things that did seem to be different. So if I can just turn to policy 5, the LDP 2 policy 5, and just ask the council. I noticed in policy 5, which is very similar to policy PM3, but in this version there's no reference to viability. Was the removal of viability a conscious policy change? Do you know?
That is something I don't know. I'm not involved in the LDP process in terms of the policy formulation and changes made, but it is in our supplementary guidance policy position.
Would the current supplementary guidance that was produced for the current local development plan, would that carry over to the new LDP2, or would you have to create new statutory supplementary guidance?
It remains in force until it is reviewed, and my understanding is it will be reviewed. I don't have a time scale for that.
Am I picking you up right that I shouldn't attach any significance to the fact that the phrase about viability has been removed?
Not that we're aware of.
Appellants, any thoughts or comments?
Not in that respect, sir.
I'm going to push you a wee bit. The previous policy gave a viability as something that you've invited me to consider as self-evident. This doesn't mention viability at all. Does that not mean it's a requirement?
I think, firstly, the note to the policy refers to the pre-existing guidance, which clearly includes contemplation of viability being an issue. And secondly, if it was so interpreted as to rule out of account viability, it's unlikely to be an unreasonable policy. So I would be very surprised if the removal of a reference to viability was a conscious decision to make that to take that out of the plan. And the note does suggest that it's contemplated that the current it will apply to the current guidance.
Okay, thank you. Community Council, any thoughts on this? No. The next one I picked up was policy 55, if I can, which is about air quality. And again, if I could start with the council, that's written in a very different form to the previous equivalent policy on air quality. Does that signify a different approach?
Don't know why there has been a change in the wording, but environmental health policy and legislative background still remains the same.
If I can just ask you to look at policy 55. In terms of the two applications before me, what sort of assessment do I have to undergo to see whether the proposal complies with or not?
terms of this proposal, I think you'd be looking at the 5th paragraph in the policy where any proposed development that could have a detrimental effect on air quality through exacerbation of existing air quality issues or introduction of new sources of pollution must provide appropriate mitigation measures.
So whilst it's written in a different style and set out in a different way, the essential policy tests are the same as the previous one. Is that fair?
Yes, while it's written differently, it's still asking and looking at the same issues.
Community Council, any thoughts on that policy? Appellants, any thoughts?
Not expressly, sir, just to make reference again to the air quality assessment that was submitted in support of the applications and associated mitigation measures, including the introduction of low emission and green technologies.
Okay. Can we now turn to propose the site-specific proposal? And there is a series of criteria for redevelopment, and that has a restriction that only the conversion of the listed buildings can take place. For the council, does that mean that the proposal for the 58 units would be okay in terms of traffic impact terms?
It still has a site-specific requirement for a transport assessment to be done. So, no.
Appellants, any thoughts or comments on this proposal?
So it's just to make reference to the fact that the appellants have submitted representations to the reporters who are considering the local development plan. Those representations related specifically to the requirements to restrict the development coming forward in the context of Crosstown.
Perhaps I can add to that, that the policy, the second bullet point clearly only catches planning permission in principle. And the clear implication is that other development will be allowed before the opening of the CTLR in terms of strategic overview. We're coming back to a sort of similar discussion we had on the embargo, but if one was to use the transport assessment to only, to in effect, extend the second bullet point to cover all development on the site, you'd be imposing a new policy requirement which is not there. That's the first point I'd like to make. Second point, to build on Mr. Littlejohn's point that this is a contentious issue in which we will potentially hear the result on the 9th of July. Even if that requirement stays within the plan, there would be conflict with that element of the policy. That doesn't necessarily lead to conflict with the policy or with the plan as a whole. And if you accepted the appellant's evidence at the inquiry session, that would not justify a refusal.
Council want to come back on those points?
So just to say, the point is transport assessment will require including sense of phasing of the site, and we have to look at both sites. I don't necessarily agree with what the friend said, but I think it will potentially be significant. We don't know what it's going to say. We're back to what the examination report is going to say in relation to the other criteria.
Okay, Community Council, any thoughts on this?
Yes, sir. Obviously, we're very supportive of the contents of MU336. It highlights the key issue of the development of this site, both for a phase 1 and a phase 2, in as much as there is a real challenge with regard to the supporting infrastructure, particularly the road network, and the danger of any negative impact on that. And I think it fairly clearly spells that out.
Okay, are there any other points we need to look at in terms of the LDP2? Are we done? You don't have to take advantage of this, but again, I'll give the parties the opportunity to tell me the overall conclusions they feel I should draw from the emerging local development plan. If we start with the council.
I think when the site-specific criteria is fully in place, it'll be, and we're in better knowledge of what those requirements are going to be. I think that'll be a good time to return to see how the development would be assessed against those site-specific criteria.
Community Council?
I don't think we've anything to add to an earlier statement, sir.
Appellants?
Nothing particularly further to add, sir, other than just to reiterate our position that the first point on the site-specific developer requirements relates to one aspect of the site.
Okay, if we can now turn to 5B, other Perth and Kinross policy guidance and advice. And the first bullet point was transport policies. The Council included a number of transport studies and policies within your core documents. What are the key points from those documents that you would draw my attention to?
I think the issue for us has always been the issue of the bridge end junction. It's been a known problem for a number of years, and I think it's just the numbers that have come out at the end of the day through the transport assessment that we've had concerns over. I think we've also mentioned several references. There's been a few references today about the cross-tail link road. Perhaps that's something that I know will be discussed tomorrow in detail, but it probably will have a significant effect on these applications.
Parents, any thoughts or comments on the various transport policies that I've been directed? Community Council?
I think just to pick up a little bit on Mr. Dean's comments, we perceive the focus on Bridge End Junction as a bit of a microcosm of the real issue here. And there's a great danger that we become rather focused on, like looking through the microscope and missing the real issue, the bigger picture of the traffic congestion in central and particularly east central Perth. And that's where the cross-tail link road, of course, becomes of primary importance. So I think we should be aware that the issue that we face here is slightly wider than the Bridge End Junction in scope.
Okay. Anything else on Perth and Kinross policy guidance and advice? We done? Me too? Okay. Let's move on to item 5. Are there any other published guidance and advice that the parties would wish to draw my attention to? I'm going to go around the tables. Is there anything from the council? Community Council? Appellants? Okay. Are there any other relevant matters that we need to discuss? No? No? We done? Okay. Well, according to me, that means we've finished our agenda. So, on that basis, we'll close today's hearing. I don't think it's worthwhile starting any inquiry session just today. I need to write up my notes and change gear into inquiry mode. We will be making some changes to the room layout, so we'll probably push the Community Council table back a wee bit, the Council back and along, because we'll need a witness table here, and I'll probably go back a little bit. So once you all left, myself and Mr. Murray will move the furniture. Otherwise, I look forward to seeing you at 9:30 tomorrow, and we will commence with the traffic impact inquiry session. Thank you very much.